Hello, everyone, and welcome to Uncivil Law. And for today's story, we have Louisiana corruption inception. I hope you like corruption, because if you like corruption, I have corruption inside your corruption for you. We got corrupt police officers who were investigated by the district attorney who were corrupt, who were investigated by the U.S. attorney who were corrupt. We got all kinds of corruption, levels of corruption. We've got many guilty pleas and guilty verdicts that are all being set aside because of the levels of corruption. It's Louisiana and corruption, man. Those are two words that never go together. Let's get started with this. In the anarchy that followed Hurricane Katrina, and we're off to a rousing start, a group of heavily armed New Orleans police officers were dispatched to the Dispensing Bridge in response to an emergency call reported shots being fired at the police. There, amid the chaos, the police themselves shot and killed two unarmed men, one of them who was disabled, and wounded four other unarmed civilians. So just really good work by the police here. Incidentally, they were using weapons that themselves might have been illegal. So there's also that. There was suggestion that they were using weapons that they were not authorized to use and may have been illegal. The police then orchestrated a cover-up to deny that this occurred. Some of these involved were tried by a state, but a mistrial was ordered because it was so bungled. The federal government took over the prosecution and themselves bungled it. Those responsible have been sacked. Those responsible for the sacking have also been sacked. 5 former officers have been convicted of serious crimes and received lengthy sentences. But because of all the screw-ups, they've got a new trial. This is great. The reasons for granting a new trial are novel and extraordinary. No less than 3 high-ranking federal prosecutors are known to have been posting online anonymous content to newspaper articles about the case throughout its duration. No, you're not allowed to do that. The government makes no attempt to justify the prosecution's ethical lapses, which I guess that's one word for it, lapse, which sounds like kind of not a big deal. Okay, when the court describes as creating an online 21st century carnival atmosphere. Not only that, but the government inadequately investigated, no you don't say, and subsequently delayed the ferreting out of information among its in-house contributors to the anonymous postings. The district court also found that cooperating defendants called by the government to testify lied. They lied under oath. An FBI agent overstepped, defense witnesses were intimidated from testifying, and inexplicably gross sentencing disparities resulted from the government plea bargaining and challenge practices. So all kinds of fun stuff are happening. So this starts with corrupt police officers who shot and killed unarmed people at a bridge using potentially illegal weapons. There was an internal investigation, which itself was corrupt. The prosecutors were corrupt. And then the U.S. attorney came in, and the U.S. attorney was corrupt. There's no end to the corruption. It's just a corruption. It's a corruption Russian doll. Nesting levels of corruption. It's turtles all the way down, except in this case, the turtles are corruption. Yeah, good times. Let's learn a little bit more about what happened in this case. A federal grand jury returned a 25-count indictment against former New Orleans Police Department's officers Kenneth Brown, Robert Gervis, Robert Falcon, Anthony Vilvaso, and Arthur Archie Kaufman for their roles in the shooting. So a federal grand jury indicted a whole bunch of officers for the shooting. Several other police officers indicted at the same time pled guilty, and most testified at the trial for the government. Despite the egregious behavior at the Dispensing Bridge, the cooperating defendants received much lighter sentences because the government agreed not to charge a series of firearm offenses for the illegal guns that carried substantial minimum requirement consecutive sentences. So because you cooperated, we decided not to charge you with the illegal possession of the illegal guns. And those mandatory minimums are pretty serious. Yeah, so we gave you a break because you cooperated. Too much of a break, as it turns out, because corruption. Emotions ran high as the prosecution progressed. Local news coverage of the impending federal indictment were punctuated by press leaks from unnamed sources that tended to favor the government. The unnamed sources being the government. One cooperating defendant, Learman signed a confidential plea agreement, and the magistrate judge sealed that information against him, sealed the indictment. So it was all sealed. But one day before they were scheduled to enter the plea in opening court, the Associated Press and the New Orleans Times-Picayune, the local paper of record, published articles announcing the fact. Somehow they got a copy of it. How? The district court ordered the government to find the leak, but no, the order bore no fruit because the government was the leak, and we investigated ourselves and found nothing wrong. Good times. During the interim between a verdict and sentencing related to this ongoing kerfuffle, so in the interim between the verdict and sentencing, events reflecting shocking breaches of prosecutorial ethics were revealed, and then compounded by further breaches. We've got breaches for your breaches. Do you like breaches? Because we've got breaches for your breaches. To make a very long story short, the district court was led on a legal odyssey by the government that began in March 2012, when another target of a federal investigation in New Orleans discovered that a high-ranking assistant United States attorney, senior trial counsel Sal Perricone, had been posting comments to NOLA.com under multiple assumed names. Senior trial counsel is making postings anonymously on NOLA.com. That's a no-no. Perricone's comments frequently involved other matters involving the United States Attorney's Office and were inflammatory, highly opinionated, and pro-prosecution. Perricone's comments were soon also tied to the Derringer Bridge prosecution and were shown to have begun well before the indictments and continued out throughout trial. So, the U.S. attorney, who is supposed to be like the best of the best and the last of our refuge, the senior trial counsel, is engaging in anonymous posting during the entire period, poisoning the well of the jury. There are rules on ethics about what prosecutors can do, particularly for the prosecution. And they kind of went, nah, and just started posting all kinds of things as the trial was ongoing, leaking information and all kinds of stuff. That's great work, senior trial counsel. You shine on. The district court's first hearing on these allegations occurred in June 2012. And here we are in 2012, 8 years later, and it's still ongoing because of the mess. At the hearing, the United States Attorney Letton was flanked by First Assistant United States Attorney and Chief of the Office's Criminal Division, John Mann, as he promised gospel truth. The chief of the Criminal Division is promising gospel truth that no one else was involved. Were other people involved? Yes, they were. Great. Additionally, the DOJ's chief prosecutor in that case, Barbara Bernstein, represented the district court that no member of the trial team had commented online. The district court acutely observed that its concern about leaks and publicity was not limited to the team. I wasn't really concerned about the team. I was concerned about the government. The district court repeatedly expressed skepticism that a new trial will be required, but ordered it to conduct new investigations. So the trial court is saying, I'm not sure there's going to have to be a new trial, but I'd like to have investigations as to what happened. And as more and more details went on, the trial court said, there has to be a new trial. And so we're on appeal as to whether or not there should be a new trial because of how bad it screwed up. The trial court didn't want to do it, but the trial court's like, you screwed this up pretty bad. So let's learn more about the screw up. Surprisingly, in the first weekend of August, while the district court inquiry were still being pursued, an extensive interview of Perricone was published in New Orleans Magazine. The interview was both revelatory and self-serving. Revelatory, among other things, was information that Perricone had actually posted comments about the pending U.S. matters under not one, but several U.S. names. So he told the press, yes, I did this. So, there's that. Self-servingly, he stated his commenting was my secret, that he had been motivated to post comments only to defend the practices of his office, and no one else in the office, specifically Letton and James Mann, knew of his activity. Excellent. The district court's November 2012 opinion, order and summarizing the developments up to that point, culminates with two overlapping questions. What is the full extent of the misconduct, and what are the institutional ramifications, and how does this misconduct, both of which have occurred and what defendants believe occurred, affect the validity of the verdicts under the criminal rules? So much stuff has happened. This court was said, no, I don't want to order a new trial. I'm like, maybe I should order a new trial. The district court was, as yet, unable to rule on the motion for new trial because it had been hampered by the inability of DOJ to provide reliable answers. So this trial court is trying to say, I want to figure out whether or not there should be a new trial. And in November of 2012 says, I can't figure out whether new trial because DOJ can't give me reliable answers because DOJ is swearing gospel truth in my courtroom. And then in September of that same year, there's an article that's published in a magazine that says, oh yeah, by the way, no, not so much. I publish these things. I did it all the time. I did it freely. And yeah. So the court is like, I'm having trouble getting good information from the U.S. Attorney's Office. So I can't rule on the new trial thing because, you're interfering with my investigation over here, trying to figure out how much corruption there's been. As the only sane man left, how much corruption has there been in my courtroom? As the answer turns out, lots. Lots was the right answer. Also contributing to this was James Mann's conflicted and untrustworthy role in the investigation. Jane Mann had stood by in open court while Letton proclaimed gospel truth that no one else in the office had posted comments, and was the sole assistant attorney responsible for investigating the extent of the commenting. All the while, the district court surmised they had been trying to protect themselves from Perry Cohn's fate. Misleading the court, always ever popular. In sum, the district court ordered the Department of Justice to recommence its investigation of both the leak and its coming, and finally answer the questions the court had raised. Could you try to answer my questions? That'd be helpful. The district court strongly urged the DOJ to appoint impartial investigators. This order was entered on November the 26th, 2012. Would this be the end of the story? Oh yeah, no, this isn't the end of the story. So in November 2012, the court says, look, there's been a lot of problems. Could you please investigate? And the Court of Appeals is saying, geez, I wish this was the end because this is already too much. But no, this isn't the end of the story. Do you like corruption? How about some more corruption? Let's discuss the more corruption. What else happened? From the end of January of 2012 until July of 2013, Horn and Alexander issued a report, followed by 4 more reports and volume of supporting material, which are best described as a whirlpool cycling towards and gradually reaching its drainage outlet. From a starting point of generality and vagueness about the misconduct within the office, the DOJ painstakingly pried more details and startling information by asking questions 2 and 3 times. So this is not going well. The Department of Justice is issued a report, and the court is like saying, but what are the answers to these questions? And 4 reports later, the appeals court says, yeah, the district court had to ask the same question like 2 and 3 times because you couldn't answer or wouldn't answer or refused to answer or misled. And so this entire process is best summarized as circling the drain. That's how this is going. It's circling the drain. That's how well this whole process is going. Way to go. Way to go, Department of Justice, on your many, many briefs, circling the drain. Wow, this is great. The appeals court is impressed. Other gaps in the investigation were evident. You don't say. Neither Perry Cohn nor James Mann acknowledged that the monikers so far discovered to have been used by them are the only ones under which they posted comments. The DOJ simply refused to follow up with newspaper reporters who had written the articles referencing 2 people familiar with the investigation and a source close to the probe concerning the leak. And in a truly disappointing and unsettling crucial development, the second supplemental report also indicated that DOJ could not forensically recover computer data from the United States Office Internet Portal from 2010 to 2011 because it didn't retain the data. It acid washed its servers, to paraphrase Hillary Clinton's issue, right? The district court attempted to discover other prosecutor misconduct was thus underlined. Yeah, we might have deleted the records, and we might not have asked the questions, and we might not have followed up with the reporters at all. We didn't even bother asking them questions about the interviews that they had done. We completely refused to interview, and we can't get the records because we acid washed our servers. Great. Way to go, Department of Justice. Has the Department of Justice heard of the Federal Records Act, where they're required to maintain records? No? Okay. Well, that's, good job. The disparity punished out by the prosecutor's office involving this whole case of the police meted out its cooperating defendants and those who went to trial as stark. The cooperating defendants' participation in the incident and cover-up seems comparable. Seems like they did the same thing, yet the government threw the book at those who went to trial by stacking firearms charges. As a result of the discharging disparity, those who went to trial have been sentenced from 38 to 65 years in prison, while the cooperating defendants gained only 5 to 8. So the court is saying, look, we recognize that there's a role in plea bargaining and all that stuff, but the ones who cooperated get 5 to 8 years. The ones who didn't cooperate get 70 years, even though they did like the same thing. Seems a little bit disparate. Seems like maybe you were punishing people just simply for not cooperating. Maybe you were being a little bit disingenuous in your pleading regimen because of all this. That was super good work. Also troubling, because there's no end to the troubling, was the saga of cooperating defendant Jeffrey Lehrman, who received only a 3-year sentence for misprision of a felony. Yet Lehrman worked glove in hand with Kaufman, who was charged with multiple felonies and received a 6-year sentence. In crafting false evidence, Lehrman went so far as to create fictitious witnesses, such as Lakeisha Smith, who doesn't exist, to fortify the defendant officer's story about the shooting. We're creating fake witnesses over here. That's the corruption. Lakeisha Smith doesn't exist, but she's a witness to the crime. Lehrman also falsely charges against Lance Madison, the brother of the murdered disabled victim. Lehrman received a favorable plea deal even after he lied to the grand jury. So the corruption knows no bounds. One of the officers faked the existence of a witness who doesn't exist and then told the grand jury about a witness who doesn't exist, which is perjury. So we were corrupt in faking witnesses and committing perjury, but we only got 3 years because we're the good guys. Corruption in my Louisiana? It's more likely than you think. That 3 supervisory level prosecutors committed misconduct in connection with the Danziger Bridge incident is beyond dispute. Perricone's comments span the entirety of the prosecution and went directly to the guilt of the defense, the collective guilt of the New Orleans Police Department, and relative competency and integrity of defense counsel versus that of the assistant U.S. attorney. I'm guessing defense counsel had more integrity, yes. Dubinsky's comments stirred the pot by encouraging commenters who were plainly familiar with trial proceedings, one of whom was Perricone, keep doing a public service with their biased reports. This is our idea of public service, I guess. The government acknowledges significant repeated misconduct by Perricone and James Mann, and to a lesser extent that of Dubinsky. The government concedes that Perricone intentionally committed professional misconduct, violating federal regulations restricting extrajudicial statements by the Department of Justice personnel relating to proceedings, violated DOJ policies, and violated court and state bar rules of professional conduct. The government acknowledges that besides the postings in this case, Perricone posted thousands of anonymous comments on various topics over the course of several years. As to James Mann, the government admits that her postings on NOLA.com of anonymous comments about the Department of Justice matters violated these rules, although the results of the postings relating to the Danziger Bridge prosecution are mitigated because they allegedly occurred after the trial court had concluded. The government also admits that Mann acted dishonestly throughout the new trial proceedings when they misrepresented facts and allowed them to be misrepresented to the trial court. In other words, lied. Don't do the lies. So after all this stuff, the district court concluded the government's protracted misconduct required a new trial under a Supreme Court holding called Birch. So, the trial court said, I didn't really want to do a new trial, but after finding out about the corruption on the corruption and the corruption, and also the fact that they lied to the court and lied to the grand juries and lied throughout the proceedings and basically inflamed passions and all sorts and so on, I'm thinking maybe at this point a new trial is warranted. And there's a Supreme Court case called Birch and said, maybe we should set aside all this and give it another go because it was all horribly corrupt. And so the government's like, but we don't want to set aside these corrupt verdicts. And so the Court of Appeals has to figure out whether or not to set aside these corrupt verdicts. We are 8 years into this mess and trying to figure out whether or not the district court can order a new trial or not. So let's find out if the district court can order a new trial. In the case of Birch, the Supreme Court held that to obtain relief on a collateral review, a habeas petitioner must establish the constitutional error had a substantial and injurious effect or influence in determining the jury's verdict. The district court found the government's conduct so pervasive and so contaminated every phase of the prosecution that it was unique in nature and scope and fell within this prejudice exception. So It was so bad on so many levels and so pervasive and so stuff, I didn't actually have to prove specific prejudice. It was just so horrible in every possible dimension that I didn't actually have to prove prejudice to the defendant. It comes to be a structural error in its totality. That's how bad it is. This is unique. This is sui generis because of how bad it is. And because of its totality, I don't have to actually prove as a district court specific prejudice. I'm just like, no. It's so pervasive. And the U.S. government's like, no, you need to prove specific prejudice. You need to prove that they were actually harmed. So who's right? Is the district court right that you don't need to prove specific prejudice, or is the defendant, or is the government right that no, you do have to prove specific prejudice? Let's find out. The breadth of the government's misconduct and continued obfuscation, as the district court finds, makes this an unusual case, contemplated by the Supreme Court case of Birch. The online commenting alone, which breached all standards of prosecutorial ethics, gave the government a surreptitious advantage in influencing an opinion, the veneer panel, and the trial itself. And by degrees, the district court was led to conclude that which it had previously considered to be isolated missteps was actual evidence of a pattern of misconduct that permeated every stage of the prosecution. And because the government refused to adequately investigate its errors, covered up what it knew to be misleading omissions, and in some instances lied directly to the court, the district court could neither uncover the extent of the prosecution's transgressions nor determine the severity of the transgressions. The government's unrelenting efforts thus prevented the district court from evaluating the fairness of the trial, and thrust the prosecution into rare territory of Birch hybrid error. So initially, the trial court was like, no, I don't think we should issue a new trial. These seem like isolated incidents. And then it ordered an investigation. And then through the unfolding of the investigation and the fact the trial court had to ask the same question 2, 3, 4 times, and even more, the fact that it just kept going and kept going, the trial court said, okay, no, we're not in isolated incidents where I have to prove prejudice. We're not in just a series of errors. We're in a systemic, ongoing, purposeful plot to deceive the district court. And so the Supreme Court left an exception which seems to be heretofore unused. That's how rare it is. This seems to be the first time it's ever happened ever. The Supreme Court said you can set aside for basically 2 situations that are relevant to this situation. There are other things beside this, but 2 things that are relevant. Either one, you prove a thing that happened that proved a specific prejudice. And maybe there's a series of these and you have to prove prejudice. And he also left open an exception, the Birch exception, which is heretofore unused. And the district court said, I'm going to use the exception. And the exception is where it's so pervasive, so systemic, so complete, so total, I don't have to prove prejudice. It is just so infused in every step of the process. And the United States Attorney says, this isn't that kind of case. And the Court of Appeals has said, you know what? Apparently this has never been used before ever. This is an exception that was merely contemplated as a throwaway, but you are so completely corrupt at every stage, and you have frustrated the district court's attempt to investigate this at every step through multiple processes, and you have misled, if not outright lied to the district court. The district court was within its prerogative, maybe for the first time ever, where the district court can say, no, I'm setting aside all these pleas, all this stuff. This was so corrupt from start to finish that I can't figure out what's happening. And so I'm just going to set aside all these verdicts and just set everything back to square one. It's the only way to figure this out, because everything is so completely corrupt from stern to stem. That's how bad it is. This is what we call in law sui generis. It basically means self-generating. It's when there is a situation which has never popped up before, and you are the case. You know, when you are the case, like we always cite the cases like, you know, Miranda or Brady or, you know, Heller or Tinker or whatever. Like we have these catchwords. Well, there was a time when there wasn't a Tinker or a Heller or a McDonald or any of these cases, right? There had to be a first. And so you, myself, are now a byword. You are sui generis. You are so bad, you are self-generating its own rationale. You have created within yourself a rationale for doing what we are doing, self-generated on its own. That's how bad this is. Congratulations on completely generating a new field of law because of the many levels of corruption. So now we have the Bowen Doctrine for when it all goes completely to hell. That's what this case is for. Great. In sum, while demonstration of prejudice is ordinarily a prerequisite for the grant of a new trial, the Supreme Court has identified this type of extraordinary error that will dispense with the burden. So normally we do need prejudice, but there is the extraordinary, and you're it. Such errors occurred here. Prosecutorial misconduct commenced even before the indictments were handed down and continued throughout the trial and into post-trial. And this misconduct affected the prosecution and trial in ways that cannot be fully evaluated. It affected the trials in ways that cannot be fully evaluated due to the government's mishandling, to put it politely, of an investigation into the cyberbullying. The online anonymous postings, whether products of lone wolf commentators or informal propaganda campaign, gave the prosecution a tool for public castigation of the defense that it could not have used against them otherwise, and doing so deprived them of a fair trial. The district court's steady drip of discoveries into misconduct infecting every stage of the prosecution, combined with governmental continued obfuscation and deceit, renders this a rare occasion of imposition in which the breach remedy is necessary. You win the prize. Congratulations. For the foregoing reasons, we find no abuse of discretion in the district court's grant of a new trial to the 5 defendants involved. So that is the end of the coverage of the case United States of America versus Kenneth Bowen. A case that is so extreme, it becomes a byword unto itself, the Bowen Doctrine, when things go so horribly off the rails. So for those of you wanting a summary, the police went to a disturbance with illegal firearms. They shot at people who were unarmed and defenseless. They investigated themselves. They covered up the investigation. The prosecutor's office investigated the police, who covered up the investigation. The U.S. attorneys investigated it, who covered up the investigation, then proceeded in a disinformation and misinformation campaign and leaking in violation of law and ethics and everything else, and so prejudiced the trial of people that, all these people have to be retried in what is the corruption, which is a corruption case of such unique scope that it is now sui generis and a case unto itself. So we have the Bowen Doctrine. This was worthy of a read, man. You don't normally find this level of corruption, but it's New Orleans, it's Louisiana, and they do have a bit of a reputation, which appears to be well earned in this case. So I guess we get to go back to trial and try to figure out whether or not any of these people did anything wrong, and maybe this trial will go better. But that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.